I think to start, soos ek reeds gesê het, we will be switching. The speakers can speak in either Afrikaans or English, so we will be switching between the two languages. But perhaps if we can start with Advocate Engelbrecht to give an introduction to your perspective on this issue, maybe in terms of what you gather from what was said today, but also I think just to maybe tell the audience in which of these cases were you involved as an advocate, and your comments on the way in which they played out.
Yes, thank you. Yes, I feel like I have to apologize to the audience. I feel responsible for some of the outcomes and some of the matters that we've discussed. I was involved in the Agri-SA case, appearing there as junior to Martin Brassey for one of the amici in the matter. I was involved in the Renata Barnard case from the Supreme Court of Appeal level and at the Constitutional Court level, again as junior to Brassey. I was also the junior in the Department of Correctional Services. We started literally from before it was launched in the Labour Court throughout. I was led then also by Brassey, but in the Constitutional Court I was led by Jeremy Gauntlet. And then in the Free State language case, I was led by Johan de Toy, acting for AfriForum and Solidarity. By the time we reached the Constitutional Court, we didn't appear there, we only made the submissions. And I was then led by Alfred Cockrell, who settled the final submissions to the Constitutional Court. So I was involved in most of these. I was also peripherally involved, in a sense, in the regulations case, the schools regulation case, because we did bring some applications associated with that. And prior to the Constitutional Court case being heard, there was a proposal being made about changes to Afrikaans language of instruction at a variety of schools on a list of about 104. And Johan de Toy and I acted for FETSAS there. We obtained an interdict. I've got a few things that come from John's presentation today and from what Koos has said. I think the first thing that I want to observe is, in my experience, the Constitutional Court has a keen sense of what is acceptable. It doesn't want or like the type of criticism that is being levelled against it. For example, that it is not impartial, that it is pursuing a particular agenda. And it is for that reason that we sometimes have explanations of we are not partial, that the need is felt to explain themselves. They often say the right things. I remember with the Barnard judgment, when it came out, I couldn't be at court that day, but Martin Brassey went unusually as the silk to note the judgment. He was so convinced we would win, and he wanted to be there for the celebration. When he heard the outcome, he phoned me and he said, "I don't want to read this judgment." But we had to. We had a conference a little bit like this one a few days later to discuss the judgment and its outcomes. So I sat as the good junior, read through the judgment, and phoned him and said, "You should read it. It says a few things that you will like very much. It says the right things about flexibility, about people being up to the task." The problem lies not in the principles expressed so much as in the outcome. It was the same a little bit for me with the Department of Correctional Services case. The thing that stands out there, and which we cannot avoid, is the court was very willing to say that the standard was not one by which we could measure, because it didn't bring the right demographics into account. In other words, we had to look at regional demographics. We didn't, therefore the plan was not good. And on that basis, the court was very happy to say, for the coloured applicants, that meant that the wrong standard was applied. But somehow logically, nobody thought of saying, well, it might also have been that the conclusion that the quotas would not have rendered white men overrepresented could also have been drawn if that plan wasn't the right one. See, the assumption was simply made that the white man would still have been too much of another appointment, despite what the actual demographics said. And I think that's what one learns with the Constitutional Court. There is often a willingness to express the principles, but when it comes to particular individuals to whom it must be applied, there does seem to be a bias. What's interesting is a further case that was not discussed here was the case of, I call it Saripa. It's the case of the appointment of insolvency practitioners through the Master's Office. And what happened there was a formula developed where the first 4 appointments would go to black women, next 3 black men, next 2 white women, and then last one to white males and everyone that was born after 27 April 1994. So that was a little bit of a mistake actually that the department made. So what they said is everybody together with white males into that last category, and they can only get 1 of the appointments. The unfortunate part was that in the lower courts, the courts were very happy to express themselves harshly about how wrong the system was, both in the High Court and in the Supreme Court of Appeal, to say that it was wrong to assess people on the basis of their race. But when it came to the Constitutional Court, what did the Constitutional Court do? It didn't engage with that question. It didn't engage with the question that this was an absolute quota. It ran away from saying that is just wrong. It found in our favor, yes, but it found in our favor on this ground that it was not proper to have put everybody together in this one class. That was the mistake apparently. Not the fact that there was a 4-3-2-1 appointment, but simply that last class was just too big. The reason I say all of this happens is because there are certain assumptions made about who the beneficiaries will be of the approach ultimately. One assumes that if one has a transformational and transformationist interpretation, that mostly people of color will benefit and white people will not. But it's not true. In the case, for example, of Department of Correctional Services and Mr. Twala was represented by Solidarity. He did not get the appointment because black men were overrepresented at the particular level, just like Renate Barnard. He suffered the same fate as a black male. They wanted a woman in that case, a black woman particularly. Now, eventually that case didn't make its way to the Constitutional Court because it was settled, and rightly so, on the steps of court. But we make wrong assumptions about who will benefit, and I think the Constitutional Court makes wrong assumptions. We don't think about what the consequences will be. That's why it's so easy for the judges to say, we will extend the Barnard principle to everybody. It's not always true that those who will benefit from this very strict sort of quota system will always be those who were disadvantaged in the past. I want to make this comment precisely because we said earlier that there is no such thing as talking about substantive equality versus formal equality in the Constitution. But it is so that people favor a substantive notion of equality rather than formal equality. The funny part is this: when we have absolute adherence to numbers, that is formal equality. That is not substantive equality. That's not engaging with people and who they are and giving them benefits according to who they are. It is simply saying, if the numbers are right, then there is equality. And I must disagree with that notion. And then I want to make one final comment about what we've discussed here today. It is absolutely my experience, having acted in these various cases, that the identity of the applicant matters. It shouldn't, but it does. And I think Justice Froneman gives us that hint very clearly. I don't know whether that's his own view or whether he's signaling a warning because of what had transpired in the debates behind closed doors. But what he is saying, if Solidarity and AfriForum hadn't brought the Free State language case, it might have been different. It said in very nice words, should have different voices, etc. And to me, it's very interesting because in our own assessment of the strength of a variety of cases, Free State language, Pretoria language, and then the Stellenbosch language case, we thought the Stellenbosch language case was weaker than the others. But that was the case that was ultimately pursued not by AfriForum and Solidarity, but by Gelyke Kanse. And the interesting thing is that in the Gelyke Kanse case, the Constitutional Court is willing to entertain the application for leave to appeal, to at least hear argument on it. It wasn't in the case of the Free State language debate. And I think it does tell us that the identity of the applicant matters. Yeah, one final thing I wanted to say is that it's interesting how others have noticed. So, for example, the South African Human Rights Commission, in the report, its equality report, made the comment that the interpretation of the Constitutional Court of the Employment Equity Act was very loose. It was very difficult to follow, and it has now made comments in that report about the fact that it doesn't seem that the Employment Equity Act is aligned to the Constitution. The funny part is, even the Human Rights Commission now seems to be running away from its own report. It says, no, the words say what I mean, I say they mean. In an Alice in Wonderland world, it's the same. They have said that there's a constitutional problem, but now that it's being picked up by Solidarity and AfriForum, they say, no, that's not actually what we meant. Just going back again to the fact that identity of who says it matters. I think it also matters often how you say it. But that's a debate for a different day. Thank you.
Ernst, baie dankie. Is lekker om hier te wees. Ek het baie lekker geluister. Ek het ook John se stuk gelees. En ek kan eintlik met baie min verskil of kommentaar gee. Ek dink die Koos was so beledigend teenoor 'n sekere hofamptenaars wat hy bang vir was, nee. Was heeltemal in orde. Jy moet in jou ouderdom sag raak. What I would like to point out on in terms of John's paper is what I thought was useful were a set of polarities that John pointed out. And I think some of those for the younger people around here could actually be further studied and researched and could really help us to understand this. And these are, if I can mention a few, the whole question of a liberal view and a progressive view. And obviously, I don't need to embroider on that. Whether the Constitution, what would happen if it had a liberal interpretation rather than a progressive one. So that's that axis. The second one, more substantive, is the whole question of targets and quotes. I'm actually surprised that no one has taken that up as an issue, especially in terms of what the court said, that it would not be wise to do it. Why would it not be wise to do it? I mean, it's a vagueness that I think could help if we can say, so what is the difference? Is it only flexibility? What exactly is that flexibility? Targets, quotas, because I think that's what it'll boil down also in the new Employment Equity Act that's on the table. The third one is the one that John also mentioned, the difference between broad representativity and equitable representativity. I think a bit of further study there would help us. And then what Gretha mentioned, equality versus substantive equality. And then the other one, the final polarity, is the phenomenon of what I would call in some judgments honorable and or naive expectations versus unintended consequences. And I think Johan van der Westhuizen, for instance, with a naive view in one of the cases, I can't remember which, saying that this may not happen, and he did, when there was merit against affirmative action. And that, I think, in a sense, is perhaps politically, could be the most devastating criticism of transformationalism, as Koos said. To say that you wanted to achieve this, you thought that the court had a role to play. Look at this, it didn't happen. I think that could be quite strong. Two last things on John's paper. It would be interesting to check how often and how prominent are the words redress or herstel. What's herstel? Correct. They used in the Constitution. So that might be another interesting thing. To just check where they are, because there are some oblique references to that. And whether in that context one can say, well, that could lead to transformationalism or not. I think that's important. But the final point on John's paper is for me that he showed clearly that the Constitutional Court has fallen in with the government of the day in re-racializing society. I often say that when I was a student in the 70s and a young Dominee Reverend in the 80s, I specifically stepped away from a racial identity because I thought it wasn't important. And this government, for the last 20 years, is forcing me, through legislation, through all the things we're talking about, to be a white person again. And I refuse just to be a white person. I think I'm more than that, but they're saying, you're a white person, and that's what matters. And I think that's where the ideology part comes in. Apartheid was an ideology, and the ideology has many characteristics, but one of them is that it changes your view of reality. It's like you see reality like this, and then you put on a pair of glasses, and you only see those four guys sitting there. It shuts out the rest of reality. And I'm afraid that the time has come for us to say to the ANC in many forums, and also to the Constitutional Court, that you have a racial pair of lenses on. Your ideology makes race the most important factor again. And I've said it to some people, and they get very angry that you can compare transformation with apartheid. But there are some things that they have in common. On Koos's paper, I like the idea of transformationalism. Perhaps we should all start talking about it. Because coming from a theological background, obviously transformation, the concept of change, is a Judeo-Christian concept. There's nothing wrong with that, but they've taken this and made it racial, almost only. And I think so. I like that idea of using transformationalism just to make the point. I would like to add to Koos's paper the perspective that, although it was news to me, and I would like to go and do some more reading on it, that it started, the idea of the concept of transformation as a political and legal concept, started with some leftist academics and the like. But I think that in the Thabo Mbeki years, especially after his speech, I think it was in 2001, of the Two Nations speech and the colonialists of a special type, it started gaining traction inside the ANC, and therefore it went through that. It will also found its way into legislation. And the ANC has been very successful in one thing. Let's face that. They've been very successful in popularizing the ideology of transformation. Very few people have the guts or the knowledge or the political incorrectness to disagree with transformation. It's like, disagreeing with holidays or something like that. And I think when I think what could this audience do, it's try to discredit that, to hollow it out in a certain sense. So I wanted to add the point, Chris, that I think if you look at what happened in governmental circles, there was it became law. The words crept into legislation. It was confirmed by the Constitutional Court, and so it went on and on. And obviously, in the Zuma years, Zuma had different agendas than transformation, but the ideology had already been formed. So it ran, and it's still running. And can I say, one of the other reasons why I think the ANC and Mbeki specifically resorted to this ideology is that they failed in transforming the country according to the precepts of the Constitution, in the good sense of the word. And a failing economy, although Thabo didn't do bad until 2006, and then he was ousted in 2007. But they failed. The education system failed miserably. And that means merit all of a sudden became more difficult. And then Zuma brought in not only more cadre deployment, stronger, he actually buggered up cadre deployment, and they didn't ask who's the best person to turn around state-owned enterprises, but rather who's the closest person to Zuma who can give us the money, the contracts from state-owned enterprises. Finally, one must ask the question, what should we do? I would think that within sort of a fairly narrow perspective, we all agree that this is a bad thing, this is what's happening, but what could be done? And I think Koos's point about the JSE is a very important one. But I think we should also say this is not only true of South Africa. I mean, there are now people waiting for Obama-appointed judges to retire so that the Trump judges can do some things in their Supreme Court. But is there a better way? Can one take, for instance, the sort of stranglehold that political parties and the ANC specifically has on the appointment of the Judicial Commission? Can one, through advocacy, say there should be more civil society representation there? Perhaps that's one thing we could do. And advocacy on what does the ANC really mean, and the Clark Foundation and IRR is working on something for next year, 2 books that Anthea is working very hard on, to tell people what is happening, what is the outcome of the NDR, what is the outcome of radical economic transformation. Perhaps, Anthea, we should consider writing a chapter on the Constitutional Court in that too. Finally, sometimes, perhaps just to keep sane, one tends to wonder whether is there anything positive somewhere. And I would want to say there are at least 3 things positive that may change the direction of discussions. The first one is what Gretha mentioned, the Human Rights Commission, with a little push from Afrika Forum and Solidarity. At least they wrote it. I mean, they can back down now, but it's on paper. And obviously the international support for that. With that, the Equality Court on our hate speech, the LAPI. Gelyke kanse, the interesting thing is it's not only did the Constitutional Court say they will hear gelyke kanse on the Stellenbosch language issue, but more importantly to me, the heads of argument were in English, but all the other evidence documents were in Afrikaans. Many of them colored students and colored leaders who said, we cannot progress in English. And so the Constitutional Court said they want a postponement so that all that 5,000 pages of evidence could be translated at their cost, the cost of the court, into English. Now, I hope that shows a new indication of let us hear what people say, especially then brown people or colored people, about Afrikaans, because I think the Chief Justice was very, very wrong and narrow in his view in the Free State case to say that Afrikaans is actually the cause of all of the racism at Free State. I mean, I wrote about that when you read his language, it's as if the Rates 4 were on trial and not Afrikaans. I mean, that's the way he came across. And yet there may be a small change in that from the Constitutional Court, and we'll have to wait and see on that. Thanks, Ernst.
Very good. Mr. Churchill said that you must believe your opponents and plan accordingly. Now, if the Constitutional Court is talking about radical socio-economic transformation, I believe them, and I plan accordingly. Now, I want to compare the situation or the choices of 1948, when the National Party took over, with the choices the ANC made in 1994 and afterwards. Now, 1948, it was a logical decision. It would have been a logical decision for the voters to support Jan Smuts at that time. We all know the history. They've just won the World War, the Allies. There was a rise of communism, the awakening of Africa, the British Commonwealth, very powerful politically, economically, and even military. So it would have been, in a certain sense, a logical choice. But the choice went in another direction. And on the face of it, it may seem illogical. It was a road of growing isolation, and South Africa at that stage, the government was basically alone in their fight against the awakening of Africa, the rise of communism and all that. But if you take a little bit of a deeper look into the forces of history, then you can see that that road they took was historically determined. And what I mean by that is, if you look at the history, the struggle against British imperialism and really the struggle for survival of the Afrikaners over the centuries, make it a historic determined outcome. They strive towards a republic, establish an Afrikaner political system, a new economic system. Luckily, I'm very glad about the baie bly oor die matriekstelsel wat ingestel is. They establish their own cultural system. Eintlik is die land geafrikaneriseer in die 50s en die 60er jare. Now, if you look at 1994, Francis Fukuyama wrote about the history, the victory of liberal democracy and capitalism. It was the golden twins become the gold standard of the world, and in that circumstances, the Cold War was won by the West, and in that circumstances, it would have made sense if the ANC accepted that golden standard of the West. Now, because of the balance of power at that stage globally and in South Africa, the ANC made concessions to get the power, and afterwards they used the power to realize a lot of their original objectives. Now, in a sense, the core difference for me between the liberal kind of role or view and the progressive, so-called progressive view of the left is the role of the state. And, I think for the most of us, we see the role of the state as a housekeeper, but that the left sees the state as a breadwinner. And what we see in South Africa is, like in 1948, you can't pause history. If you look at the driving forces of history, from a liberal Western perspective, we see the Constitution, the most important thing, as liberty. But from another perspective, you see the most important thing as equality. And I talk about equality of outcomes, to use the state to realize the second generation equality rights, and not to protect the first generation freedom rights, liberty rights in the Constitution. So if we look at the broader picture in South Africa, we see the systematic use of political power to diminish the cultural spaces. We see the role of the Constitutional Court to promote the legitimate interests of the majority, even at the cost of protecting the legitimate interests spelled out in the Constitution of the minority. So, for me, the most important thing is that I don't believe you will be able to stop history. I believe the ANC will accelerate the pace in the wrong direction. They talk about the balance of power. The balance of power has changed in South Africa, as you all know, but also from their perspective, not necessarily correct, but from their perspective, also there's big changes in the global balance of power, and the ANC look much more these days, if I can use the term, to the Beijing consensus of economics, of a political economy, than the so-called Washington consensus. Thank you.
I have two questions, one for Gretha and one for Theuns. The question to you is, in the Tshwane case about the street names, the case was essentially about a procedural matter, about the process that has been followed in changing the street names, and the court said, they made that comment about substance over form, where they said, basically conceded that the process that has been followed wasn't legal, but the outcome was proper and therefore it should be accepted. So the question to you is, to what extent is that acceptable or appropriate in a court judgment? And my question to you, Theuns, is about the context that we are in now, and you obviously played a role at Gretha at the negotiations. So the question is about the narratives and the different narratives that we see in South Africa and the extent to which they are reconcilable. So we do know during the negotiations the ANC had certain promises that they made to their support base or constituency, and the National Party made certain promises to their constituency on what the new South Africa would look like. And it seems today as if both constituencies are frustrated because what happened is probably somewhere in the middle. So the question is whether those two could be reconciled.
Thank you. In administrative law, what we know is that there is a process to be followed, and we know that when a process is not properly followed, that is a proper basis for a challenge. We accept that in administrative law in particular. We accept it also in the sphere, for example, of labour law, where we don't just look at what the outcome is and say, well, it really doesn't matter so much that the process didn't work out right. Because we know that the process and the choice about process influences the outcome in ways that we can't always predict. And so as a lawyer, I would say that you can't simply excuse procedural flaws because you have a loose sense that the outcome was the right one. But your question goes precisely to my point that I made earlier. The court is concerned ultimately with outcome. It says certain things in getting there, but its concern in the transformation project seems to be what is the outcome. And you see that in the example of the Free State language case. The outcome, for example, of having Afrikaans and English classes was that predominantly in the Afrikaans class there were white children, and predominantly in the English class there were black children. That's the outcome. So what the university and then ultimately the Constitutional Court sees is that is racist, because the outcome is to have different groups in different classes. It looks at the outcome, not at the actual actions. And I think that is a tool, maybe. If you go back to the street name case, if you start looking at the outcomes and you can start justifying interference on the basis of outcome, that is how you justify getting there, because you can ignore some of the more difficult technical objections.
Ernst, thank you. The circumstances around 1994, just to remind everyone, was that we were negotiating an interim constitution in 1993 to enable the country to move away from violence and have an election. So the only reason for the interim constitution was to be able to call a legitimate and legal election by an elected parliament. Obviously, the sort of 80% of the interim constitution found its way into the final constitution of 1996, and some of you may know there were the 34 constitutional principles that had been agreed as in very many cases as a compromise between the parties, that of those 34 principles contained in the 1993 constitution must also be in the 96 constitution. And as far as I can remember, the constitution was sent back twice to make sure that happened. So it is true that because there was a time frame, because the parties were under pressure, there was what was called in the past the vagueness of compromise. That parties could find each other in the vagueness of compromise. And obviously that led to what you referred to, Ernst, that there were different expectations from the different constituencies. I often said that white South Africans hoped that nothing ever would change, and black South Africans hoped that everything would change overnight. And they were both wrong. Now the question is, have we gone wrong? Could we have, as you say, reconciled those expectations? And I believe it's past tense, but I believe we could have. If three things happened differently. Firstly, if we kept to the economic principles of the Mbeki administration and not gone to the Zuma administration. Because some of you may remember we had 2 quarters of 5% growth in 2006. It wasn't exactly as most of it would want it, but we were making progress. And that then fell by the wayside. The second one is the failure of the educational system, which I think history will show was the biggest failure of the present government. And it's not changed. 25, 6 years, we still don't have a solution for our basic education problem, and tertiary education has now been added to that. And then the third one is the whole question of redress or affirmative action. I don't think any one of us, who, if we had been a decision maker in 1994, would have said that there can be no such thing as affirmative action. There was some redress necessary, but I think if redress was given a 25-year or even a 30-year window, and say, that's it, these are the principles, no quotas, no even targets, but training, education, I think we could have. Now, that's in the past. The question is it still possible? I know Flip says you can't change history. I still hope and believe, and I'm working to try to make it possible to reconcile those. But the narratives are at the moment worrying me. You know, the narrative by Black First, Land First is, and the EFF, is a difficult narrative to I mean, you can reject it, but it has some traction in the community. Give you one other example, finally, Ernst. F.V. de Klerk, when we write something remotely contentious, we get attacked from the left on social media, but we also get attacked from the right, because anything that goes wrong in today's South Africa is attributed to de Klerk, saying that you sold us out. I mean, I had a discussion the other day in Pretoria with a guy who comes from Van der Bijl Park. He's 70 years old. He has a file this thick on the referendum. And he wants me to hold F.V. de Klerk to the referendum. And eventually I said to him, you know, he's 82, you can't hold him, but even if you could, he asked for a mandate to negotiate a constitution. You must judge the Constitution, that's the outcome, not if some parties, as they do now, reject the Constitution. So I think that's the problem we have, the narrative has changed, and I think the Helen Ziller tweet and others show that little sentence in the preamble that said, respect those who developed our country, is not getting the same traction as the one who said, we fought for freedom. And I think it's perhaps time to make that balance right.